This motion sounds explosive, but the legal standard behind it is far stricter than most people realize. In a Utah murder case tied to a nationally prominent conservative activist, the defense is asking the judge to do something extraordinary: remove the entire prosecution team after prosecutors made the most serious decision they could make, seeking the death penalty. The question here isn't whether the optics are bad. The real question is whether Utah law removes prosecutors based on appearance or only on proof of actual disqualifying conflict. Now the story. Charlie Kirk was the founder of Turning Point USA, a national conservative organization focused on youth outreach and political organizing. His visibility made him polarizing, and his killing drew immediate national attention. Tyler Robinson was charged with murder under Utah law. As the case progressed, prosecutors filed notice that they would seek the death penalty. Then, the defense filed a motion that almost never succeeds: not to suppress evidence, not to dismiss charges, but to remove the prosecutors themselves. The reason centers on one fact: a deputy prosecutor's daughter was present at the event where the shooting occurred and later communicated with her father. The defense says that fact changed everything. No ruling has been made on the motion yet. The prosecution's response is direct. They deny any conflict. They say the daughter is not a witness in the legal sense. She did not see the shooting itself. She is not part of the prosecution team. More importantly, they argue the death penalty decision was not made by one emotionally effective prosecutor. It was made at the office level, with leadership responsible for the final call. Their position is simple: a family member's presence at a public event does not create a disqualifying conflict. Let's now put the defense theory on the stand. The defense doesn't have to prove innocence to win this motion, but in Utah, disqualification is an extraordinary remedy. They must show an actual conflict, a personal interest, or concrete misconduct that threatens the fairness of the proceeding. Here's how they try to do it. One aggravating factor alleges that the defendant targeted Charlie Kirk based on political expression, knowing that children were present and would witness the homicide. The defense connects that factor to the prosecutor's daughter being at the event. Their claim is this: you don't need emails. You don't need confessions of bias. The conflict is based on the charging decision itself. This is where courts draw a hard line. Here's what this motion is really asking the court to do. The defense is not just saying there might be bias. They're asking the judge to wipe out the current prosecution team and hand the case to a different county prosecutor. Why? Because a new office gets a new look. A new look means new discretion, and new discretion creates a second chance that the death penalty disappears. That's their strategic goal. But courtrooms are not reset buttons. You cannot walk into court with a narrative, an inference, or a headline and say, "This feels personal, start over." The law demands proof. Let's get precise. That aggravating factor about children witnessing the homicide does not depend on whose child was present. There were numerous young people at that event: college students, youth attendees, independent witnesses. That factor exists, yes, with or without the prosecutor's family connection. So the judge will ask one question, only one question: where is the evidence that this personal relationship actually altered prosecutorial decision-making? Not suspicion, not coincidence, not discomfort. Evidence, statements, text messages, emails, or some kind of corroborated conduct showing, because my child was there, we're seeking death. Without that, this motion doesn't weaken, it collapses. Now the law. Utah standard is intentionally demanded. Courts require proof of an actual conflict, a personal stake, or concrete misconduct, not the appearance of bias. And when conflict exists, courts remove people, not entire prosecution offices. The judge's role is not to correct optics. It is to protect due process. Here's my ruling. Based on what is publicly known right now, this motion is unlikely to succeed. The presence of a prosecutor's child at a public event is not, in and of itself, a disqualifying conflict under Utah law. Seeking the death penalty, standing alone, is an act of prosecutorial discretion, not proof of bias. And courts do not grant do-overs, simply because the defense hopes that a different prosecutor might make a different choice. Utah courts are governed by proof, not perception, and on this record, proof is exactly what is missing. If you like this kind of legal cross-examination, subscribe. This channel is all about testing criminal case headlines under the actual law and judging what actually matters. And remember, the truth matters, and so does reasonable doubt. See you in the next case.